Paul.
Good afternoon. Sorry, I'm having a little technical difficulties. Can you see and hear me?
We can.
Great. All right. All right. I'll get started. So thanks, Dan.
Thanks very much.
Nurinj, everyone. Woman Inji, Netul Muktau, Paul Payton, Naju Gunai, Naju Monero, Naju Tunganai, Wo Gunai Work. Just to introduce myself as a Gunai Monero man. And welcome you all here today and acknowledge the traditional owners of all the countries that we're calling in from this afternoon. And it's really great to see you all here today. And it's today's the third of a series of 6 lunchtime webinars that we've developed from the insights and questions that were posed back in 2019 during the traditional owner engagement meetings about treaties. So these papers are reflecting back those conversations, but I'm really enthusiastic about these opportunities as a statewide body that convenes and advocates for the rights of traditional owners. It's a series of webinars that's really going to align strongly with our one of our 4 pillars, which is around knowledge sharing, and that's designed to focus on enabling a more connected and informed and innovative traditional owner corporation and communities, which we do through the promotion of resources, events and information sharing opportunities. So we're looking forward to trying to do many more of these into the future. You know, the past few decades have seen the rights of Indigenous people increasingly recognised through human rights law, and despite strong support, almost universal support in regards to UNDRIP, with the exception of Canada, not much has been adopted into domestic law. So I think as the treaty process is now underway in Victoria, it provides an opportunity and new prospects for Indigenous rights to be recognised through that process. So today's presentation around UNDRIP and Enshrining Aboriginal Rights is one of those 3 papers that are already on our website that you can download, and there's 3 more currently underway that will be developed and presented over the next few weeks. So I think, you know, it really allows us to understand more about this space and inform us moving forward. So I think there's a lot to get through, so I'll hand it back over to Dan, who's General Counsel at Federation, and to deliver the presentation to you today. Yeah, hopefully you get a lot out of it, and that there are plenty of questions at the end that we can hopefully answer for you. So thanks, Dan, and over to you.
Thanks very much. Appreciate that. And I'll now just bring up the presentation going through today. Yeah, and as Paul said, so today this is the 3rd paper in our series. We're looking at UNDRIP and Enshrining Aboriginal Rights, Victorian Treaty Process. This forms one of 6 discussion papers we've prepared. And just a quick note on the purpose of the discussion papers. They're not put forward as positions of the Federation or our members or of traditional owners more broadly. Instead, what we're really seeking to do is contribute to the thinking around treaty and to start presenting options and ideas that can be explored and refined. But the real purpose is to start to move from rhetoric to practice, start to put some concrete about how a treaty might be formulated in this space. So, as I said, there's 6 papers in total. The first one is on understanding the landscape, foundations and scopes of the Victorian Treaty. We presented on this on the 27th of January, and you can now find that presentation on our Facebook page, and you can also find the paper itself on our website. We presented on paper 2, Sovereignty in the Victorian Context, on the 10th of February. Again, that's available through our Facebook page and the paper on our website. And today we're looking at UNDRIP and Enshrining Aboriginal Rights. The following papers will come, papers 4, 5 and 6. So paper 4 is on transferring Aboriginal control, so Aboriginal control of Aboriginal affairs and transferring many of the duties currently undertaken by government to an Aboriginal body. Paper 5 is starting to look at local treaties and the lessons that we can take from the Traditional Owner Settlement Act. And then finally, hopefully in April, we'll be presenting to you on a comprehensive treaty model for Victoria that will draw on all of these previous papers. So just to give you a bit of an overview of the proposed model that these papers collectively put together. Essentially what we're saying is that there needs to be a statewide democratic body of Aboriginal people, somewhat like the Assembly. It may be the Assembly, or it may be an evolution of the Assembly. And we refer to that as the treaty representative body. We see this body as entering into a statewide treaty directly with the Government of Victoria. And that statewide treaty would contain a number of items. So all of this is dealt with in our first paper, paper 1. And this statewide treaty would establish the TRB as a sovereign body. So it would give the TRB legislative power, perhaps a voice to the Victorian Parliament, reserve seats in the Victorian Parliament. And we look at that concept in paper 2. We also say that the statewide treaty should recognise Aboriginal rights. Principally, we say this should be done through the entrenchment of UNDRIP and making those rights justiciable and able to develop over time. And that's what we're looking at today. We say that the model should also transfer should also transfer control of Aboriginal affairs to Aboriginal people themselves. So that's essentially all government departments, statutory authorities and so on, with responsibility being transferred to the TRB, supported by an Aboriginal public service. We'll look at that in our next paper, paper 4. And finally, the statewide treaty would involve a framework for local treaties. So these would be treaties with individual traditional owner groups. We'll be exploring that in paper 5. So that's the overview of the framework we're seeking to sort of discuss these issues within. And as I said, today we're looking at this paper 3, the entrenchment of UNDRIP rights. So just by way of introduction, I think most people are aware of the UNDRIP. It's certainly the most prominent instrument in international law that seeks to recognise the rights of Indigenous people. It was adopted by the General Assembly in 2007 by an overwhelming vote of 143 nations in favour, with only 4 against. Rather shamefully, Australia sat among those 4 that opposed. So it was Australia along with Canada, New Zealand and the United States. However, all of those 4 have now changed their position and also endorsed the declaration. However, it is important to note that it is a declaration. The term declaration, when it's used in international law, is used to indicate that the states view the document as not legally binding. So it's not legally binding in international law, but is essentially aspirational. And it will only become binding if it's on a nation state, if it's directly adopted through the domestic legal system. So now we are, essentially 14 years on from the initial endorsement of the UNDRIP, and it has almost universal support. But with some recent exceptions, there's been relatively little movement in moving the document from an aspirational, unenforceable declaration to enforceable legal rights within nation states. But thankfully, I think that's starting to change, and we'll be going through that today. Should also just note that the non-binding nature of it allows Australia really to have it both ways, because it's signed up to this document and can espouse it in international forums while ignoring it at home. And we have seen, as I said, no real moves to either legislate or otherwise implement the terms of the declaration in any meaningful way. But hopefully now, through the treaty process, we have we have a new option and I think probably a real possibility to see movement in this area. So this paper is split into 4 sections. The first section, we will look more closely at what is the UNDRIP, some of its history and what it contains. Part 2, we will look at why is the UNDRIP not legally binding. I've already touched on this somewhat, but I think this is an area that's worth just going over a little bit. I hear not infrequently in traditional owner forums, traditional owners really wanting to see Australia held to account in international forums or courts or tribunals. And unfortunately, I don't think international law really allows for that. And so I think it is important perhaps just, you know, to be clear on why that is and how international law can help and how it can't. In part 3, we will look at enshrining Aboriginal rights and draw on some international examples and a limited example in Victoria, where attempts have been made to entrench concepts from the UNDRIP. And in part 4, we'll go on to propose a model for how we see it being entrenched through the treaty process. So what is the UNDRIP? Well, the UNDRIP is an attempt to list and categorise basic rights of Indigenous people as they apply throughout the world. The special status of Indigenous people has been recognised for quite a long time now in international human rights law, but the difficulty is always reducing the myriad of Indigenous cultures and producing a set of universal rights. As Marcia Langton has said in this quote, there's no single concept of Indigenous rights, but an ever-growing body of law, opinion and practice. This has really come out of the 20th century. It's come out of the demands and activism of Indigenous people and the concessions of governments, and continues to evolve. And the UNDRIP is probably now the pinnacle of all that 20th century activism in the international space. But there have been attempts to record a basic set of international rights as far back as the 1950s. The International Labour Organization, an agency of the UN, created the Indigenous and Tribal Populations Convention in 1957. This is really the first sort of attempt to document Indigenous rights at that level. This was a document of its time, and it had an assimilationist lens and saw and essentially advocated for the assimilation of Indigenous cultures. Nevertheless, it did have some more far-thinking provisions and sought to prohibit discrimination, and was the first international instrument to recognise rights to traditional lands. In 1989, the ILO revised that earlier convention, and they sought to remove the assimilationist orientation of that earlier convention, and to assert the right of Indigenous peoples to maintain their cultural and political independence. This resulted in the Indigenous and Tribal Peoples Convention of 1989, also known as ILO 169. So importantly, ILO 169 takes the form of a convention, and when signing the convention, unlike with the declaration, nation states are indicating that they intend to be legally bound by the terms of that convention. Perhaps because of this, because of the legally binding nature of ILO 169, ratification was really quite low, and only 23 nations have signed on to it. Almost all of those nations are from Latin America. Outside of Latin America, only Nepal, Norway, and the Central African Republic agreed to ratify. And from all the former British colonies, only Fiji was a signatory. So given that low take-up of ILO 169, further attempts were made to find an instrument that could be endorsed by the wider international community. And after almost 2 decades of negotiation, we get the UNDRIP, adopted by the General Assembly in 2007. As I said at the outset, Australia voted against adoption of the UNDRIP at that time. And John Howard, who was Prime Minister, said that, that voting against the UNDRIP wasn't difficult at all, because it is wrong to support something that argues the case of separate development inside one country. I think that's a useful little quote because it sort of neatly sums up conservative opinion around in the recognition of Indigenous rights. I think more broadly, conservative views have trouble and are threatened by, I think, any sense that there may be another polity operating inside a nation state. And no doubt some of that will come to the fore as we go through this treaty process, but it's a continuing strain in conservative criticism of these types of reforms. But in any event, Howard was kicked out, and in 2009, the Rudd government shifted its position and supported the UNDRIP. So what does UNDRIP say? Well, it contains 46 articles that seek to list out the rights of Indigenous peoples and communities. It affirms the minimum standards for the survival, dignity and well-being of Indigenous peoples worldwide, and recognises the urgent need to respect and promote the inherent rights of Indigenous peoples. The particular rights it lists within the 46 articles are probably fairly familiar to this audience. There are things like a right to self-determination, self-government, free, prior and informed consent, ownership and control of traditional lands and resources, maintaining and strengthening distinct political, legal, economic, social and cultural institutions, practicing and revitalising cultural traditions and customs. There is much more contained within those 46 articles, obviously, but they are probably some of the more relevant ones for Victorian traditional owners. So the UNDRIP is considered quite an accomplishment. It's the pinnacle, as I said, of sort of 20th century international activism. But it's not without its flaws or its critics. Hayden King, an Indigenous Canadian, wrote an article on the history and process of the UNDRIP, and he notes that the English-speaking states frequently objected to the draft declaration and sought to rewrite over a dozen articles and even removing some. And this was done in the face of boycotts and hunger strikes by Indigenous delegates. And he paints a picture of quite a fraught process that led us to the ultimate UNDRIP. Interestingly too, he refers there to the English-speaking states, and as we know, even though they went through this effort of rewriting, they ultimately didn't support the declaration in any event. Particularly objectionable, I think, is the revised Article 46.1 of the UNDRIP, which states that nothing in the declaration should be interpreted as implying any right to any action which would dismember or impair, totally or in part, the territorial integrity or political unity of sovereign and independent states. You can see again, this is picking up the sentiment by John Howard that there is this fear or people are threatened by the idea of a different political entity operating within a nation state. Now, what is meant by Article 46, when they say, what do they mean when they say territorial integrity or unity of sovereignty, is largely left to individual nation states, and it provides a neat little avenue for them to avoid compliance. Interestingly, when we did finally endorse the UNDRIP, Rudd noted that the free, prior and informed consent elements would be interpreted in accordance with Article 46. Perhaps they're sending a little message to interests such as mining companies and the like, that free, prior and informed consent would not get in the way of business as usual, essentially. So why is the UNDRIP not legally binding? I think to understand that, we do need to look a little bit at some of the basics of international law. So even though the UNDRIP is endorsed by Australia, it's not automatically enforceable in Australian law, as we know. And this really gets us to the heart of the international legal system and how it operates. The United Nations defines international law as the legal responsibilities of states in their conduct with each other and their treatment of individuals within state boundaries. But unlike a nation state, at that international level, there is no parliament to make legislation or to apply, or that's able to apply law internationally. There is the UN General Assembly, but that has no power to legislate for the international community. So if you don't have a parliament, where does international law come from? And there are, in fact, a range of sources. There is customary law. So this is things that have happened in international practice for so long that they essentially become entrenched and began to be thought of as laws. There are general or basic principles of law that apply in modern nation states and are generally considered to apply internationally. An example there might be the idea that a corporation is a separate legal person. That is a principle that translates into international law. The writings and interpretations of respected international institutions, lawyers and academics can also be thought of as part of making up international law. But perhaps the primary source of international law is international treaties, sometimes called covenants, conventions or protocols. These are the documents that governments voluntarily sign up to and then are thought of as internationally binding laws. So these treaties, international treaties, can be entered into between nation states or between nation states and international organisations. As I said, they are voluntary, but in doing so, the nation state is essentially agreeing to be legally bound by that document and will submit to the jurisdiction of the relevant court, international court or tribunal that oversees the treaty if a dispute arises. We have to be a little bit careful here referencing a nation state as being legally bound, as we'll discuss. That has a slightly different meaning and connotation in the international space. Now, even though a country signs up to a treaty, that means the law will apply to them internationally. It does not mean that it will necessarily apply to them within their own domestic boundaries. And the only way that will happen is if in Australia's case, if the Australian Parliament also adopts the treaty as a domestic law. And as I said, instead it remains a law at the international level, and if the law is breached, the complaint will be heard at that level. So some examples of legally binding treaties or covenants are the ICCPR, the International Covenant on Civil and Political Rights. That guarantees rights to life, individual liberty, freedom of expression, and so on. There is also the ICESCR, the International Covenant on Economic, Social and Cultural Rights, which has a more economic focus and guarantees rights around work, social security, education, health, housing, and so on. Should also point out that ILO 169, which we discussed earlier, is also a convention and notionally legally binding. As I said, these documents are entered into as covenants, as distinct from a declaration like the UNDRIP, so they implicitly have that intention to be legally binding, and in that way they are differentiated from the UNDRIP. So it might seem at first glance that in respect of international law or Indigenous rights, that moving from the legally binding ILO 169 to the non-binding UNDRIP is a move to an inherently weaker position. But I think the true picture is really more complex. And this is because by adopting a non-binding status, the UNDRIP has achieved almost universal support, which compared to the low support of ILO 169, there's clearly much more buy-in for UNDRIP. That near universal buy-in also has some potential over time to develop into customary law if it becomes the standard way in which nations are expected to behave towards their Indigenous people. And as I indicated before, even when international law is supposedly binding, it is notoriously difficult to enforce. International bodies set up to police the rights in these treaties have very limited powers to compel nation states. Indeed, for an individual or a non-government body, it can be very difficult to even access these international forums. Often only nation states can bring complaints. For instance, the International Court of Justice is only open to nation states, and individuals and non-government entities are excluded. Where individuals and non-government entities can bring complaints, for instance, under the ICCPR or the ICESCR, those treaties do allow for individuals to bring complaints, but only if their home government has opted into the process. For Australians, we have opted into the process for the ICCPR, so it's possible for an Australian to bring a complaint if there's been a breach of their freedoms and liberties, and those sorts of broad freedoms that are protected by that legislation, but not under the ICESCR. So Australians cannot bring a complaint for a breach of their right to health or housing or so on. Another barrier to trying to enforce these international rights is that you must first, usually it's a requirement that all domestic remedies have been exhausted. So you first need to go through all of the local courts and essentially engage in several years of litigation before these tribunals and courts even open up to you. Then, once you get to that international level, they usually only have powers to make recommendations, and they can't make enforcing or binding decisions against the nation state. So the concept of a binding international treaty, as you can see, can actually have quite a limited effect for an individual within a nation state. So given these limitations, human rights activists have adopted other strategies to try and make use of international agreements, and this is essentially trying to have those rights enacted into domestic legislation. Some examples of this would be the campaign for an Australian Bill of Rights that pops up from time to time, or in Victoria, the enactment of the Charter of Human Rights and Responsibilities Act, the Human Rights Charter. Where it is possible to get human rights obligations embedded in domestic legislation, they can have far and sometimes unforeseen consequences. Megan Davis points out that the Racial Discrimination Act, which is the domestic expression of the International Convention on the Elimination of All Forms of Racial Discrimination, has really been a critical underpinning to the advancement of Indigenous rights in Australia in ways that it probably wasn't foreseen to do when it was brought in 1975. For instance, the Mabo litigation wouldn't have been possible without the Racial Discrimination Act. The Native Title Act itself has some basis in the RDA, as does land rights legislation in the Northern Territory. So for these reasons, many human rights activists around the world are fighting and pushing for the implementation of UNDRIP within their home countries. So that covers basically an introduction into what is in the UNDRIP and into how it applies and works. Now moving on, we'll look at some specific examples that have been made in Victoria, New Zealand and Canada about how activists and traditional owners and their advisors have tried to get UNDRIP operative within a nation state. So we'll look at a few different ways that this has been attempted. I think you can break these down into two broad categories, which is incremental implementation and implementation across whole of government. Under incremental implementation, this can be done through individual agreements. So where traditional owners in the state enter into individual agreements, you can introduce UNDRIP concepts. And there's also sometimes ability to embed it within negotiation processes themselves. Across whole of government, we've seen recently in New Zealand some policy approaches that have been taken to try and introduce UNDRIP. And in Canada, we are now seeing legislated approaches to try and introduce the declaration. And we'll go through this in some detail. In terms of incremental implementation, we're really talking about individual agreements and negotiation processes. What I mean by individual agreements, in all settler nations, governments are essentially forced into negotiations with their Indigenous peoples. This will arise usually when they want to carry out some sort of infrastructure development or they want access to natural resources. And those negotiations will often result in binding contracts. In the Australian context, we would be quite familiar with this in the sense of like ILUAs negotiated under the Native Title Act. Recently high-profile ILUA would be that negotiated around the Adani mine, where the state has attempted to enter into a binding agreement with traditional owners or native title holders so it's able to access those resources. When we're talking about negotiation processes, we're really talking about more comprehensive settlement schemes. So in addition to the individual agreements I just talked about, settler states will also try and pursue more ambitious programs that try to comprehensively settle issues between the state and Indigenous peoples. So examples would be the treaty process in British Columbia. Another example would be the Traditional Owner Settlement Act in Victoria, and indeed the current Victorian treaty process. So when negotiating these individual agreements and setting up the processes of these comprehensive settlement schemes, it's sometimes possible to try and draw in aspects of the UNDRIP. An example of implementation through an individual agreement can be seen in the Natural Resource Agreement. So the Natural Resource Agreement is a standard agreement that forms part of a settlement package under the Settlement Act. Its basic role is to set out traditional owner rights to take and use natural resources. So that's rights to hunt and gather on traditional lands, essentially. This agreement was recently renegotiated by a committee of traditional owners, and through those negotiations, the traditional owners were able to establish what's called a partnership forum made up of 2 state reps and 3 TO reps. And the role of the partnership forum is to make decisions about the sustainable use of natural resources. So the state may seek to limit traditional owner rights to take resources if it believes it's unsustainable to do so. Now, under the renegotiated NRA, the partnership forum has to make decisions in accordance with the following principle, and that is that before entering into any decision or any further agreement, the state will obtain the free, prior and informed consent of the traditional owner group through its representative structures in accordance with international law and Article 32.2 of the UNDRIP. That article obviously referring to the obligations of free, prior and informed consent. Now, by importing that UNDRIP concept, the state will need to comply with international legal principles. It will, and all of the international law that goes with it. So there will have to be no undue pressure. All relevant information will have to be provided, and TOs will have to positively consent to the proposal and are free to withhold their consent before that can go ahead. So this is the idea of incremental implementation, where essentially, if you are able to introduce enough of these sorts of provisions in agreements and dealings with the state, they become more and more entrenched over time. Obviously a slow process and probably not the most efficient way to approach the problem. Now, implementation through negotiation processes takes a slightly broader approach. An example here would be drawn from the BC Treaty Commission. As you know, the BC have British Columbia have a comprehensive negotiating treaty process. And the role of the BC Treaty Commission is to facilitate negotiations, essentially acting as an umpire between the First Nation and government parties. This is a role that looks to be similar to what's envisaged under the Victorian process for the Treaty Authority. So in 2016, sorry, I'm just going through some questions. In 2016, the functions of the BC Treaty Commission underwent a review, and the Commission's mandate was extended. So now that the mandate of the Commission is to support the implementation of the UN Declaration. Now, if we describe the BC Treaty Commission as the umpire between the negotiating parties, we now see the UNDRIP is inserted as the rules of the game, which the umpire will administer. The BC process went further in September 2019, and they now operate under a policy in which the UNDRIP is seen as the foundation of the entire negotiation framework, and that negotiations will be guided by and treaties will provide for the implementation of the UNDRIP. So you can see slowly but surely the UNDRIP is being cemented into that process. Now, there's no comparable example in Australia of UNDRIP being pulled into the negotiation processes, but I do note that the Treaty Act makes the following statement. It says that the state recognises the importance of a treaty process proceeding in a manner that is consistent with the principles articulated in UNDRIP. I think that indicates certainly a willingness by the state that, or maybe even an expectation that the UNDRIP will be part of that process. I also refer there to Part 3 of the Treaty Act. So that Part 3 of the Treaty Act sets out the way negotiations are to occur during this stage of negotiations, which is essentially the Assembly and the states setting up a framework and the treaty authority and other structures. And that sets out a number of principles around how negotiations will proceed. That doesn't refer to the UNDRIP, but it mirrors it very closely. It refers to respecting principles of self-determination and distinct cultural and political representation and so on. So I certainly think the Victorian process is primed to adopt this sort of thing. Conscious of time, I'll try and move a bit more quickly through. So some of the policy approaches that we've seen for now moving on from incremental implementation to whole of government implementation. In New Zealand in March 2019, the Maori Development Minister announced that they were going to develop a plan of action with regard to the implementation of the UNDRIP within New Zealand. A delegation from the UN expert mechanism on the rights of Indigenous people has visited and is providing them guidance, and they've set up a technical working group which is chaired by a leading Maori academic. So the idea here is to produce a plan of action around implementation. Unfortunately, there's not a huge amount of public information available, and it seems to be that consultation process is still continuing. I noticed this was announced in March 2019, so I don't know what it indicates that there doesn't seem to be a lot of public information, but hopefully the process is continuing well. What we do know from the time of the announcement is the New Zealand government is expecting that the declaration plan could be a national plan of action or a strategy or some other tool that provides a map that demonstrates and guides progress, and will be an opportunity to establish greater coherence across government. The impression you get from reading all of this is that the plan of action is more of a tracking mechanism, that the government's saying we are taking all these measures to advance Maori rights, which is also, in a sense, implementation of the UNDRIP, and we want to start to document that. Now, that documentation might give rise to weak spots or to blind spots where things aren't happening, but it doesn't in and of itself mean that there's a commitment to address those things. So essentially it is just this sort of mapping tool rather than a direct commitment of whole of government implementation, but it certainly looks promising. Now moving on to the legislative approaches we've seen in Canada. While Canada was late to endorse UNDRIP, it's since that time it really has sort of led the way in trying to implement its terms into domestic law. In 2016, Romeo Saganash, a Cree man and member of the Federal Canadian Parliament, sought to introduce a private members bill known as Bill C262, and the purpose of this bill was to implement the UNDRIP federally. It passed the House of Representatives, but was essentially killed by Conservatives in the Senate, who refused to vote on it before the end of the parliamentary term, which under their system essentially ended the bill. Although there was this failure at the federal level, it was almost immediately picked up by British Columbia, who introduced similar, if not identical, legislation into their parliament in October 2019. And by November, that was known as Bill 41, introduced in October, and by November it was enacted as the Declaration on the Rights of Indigenous Peoples Act, or the DRIP Act. So this is the first time that any Canadian province, or indeed any legislature in the English common law world, has established a legislative framework to introduce or embed UNDRIP. So as with the earlier federal bill, the DRIP Act has 4 sections. The first one is that it affirms the application of the declaration to the laws of British Columbia. It requires a process that the government must take all measures necessary to ensure the laws of British Columbia are consistent with the declaration. It requires the government prepare and implement an action plan to achieve the objectives of the declaration, some of the same language there as New Zealand, but certainly it would seem a higher level of commitment. And finally, it establishes a process of annual reporting to the Parliament on the progress of each of these of the above three sections. The legislation is new, not much progress in 2020 for obvious reasons, I suspect. And there will likely now be a long period of consultation on how its aims and objectives are put into action. Some immediate issues to point to: the legislation affirms the application of the UNDRIP to BC law. There's some uncertainty, I think, about what this means and how it might be interpreted by BC courts. And conservative critics have suggested it's dangerous because it's ambiguous and of unknown effect. I think that they're probably overstating the case there, but it is, yeah, what does it mean to say that the Parliament has affirmed UNDRIP as applying to BC law? The other thing is that the Act requires the government address laws inconsistent with the UNDRIP. So I think this implies that they will need to institute a process whereby they are reviewing existing legislation and amending that legislation where they identify any inconsistency. I think that's quite interesting because that's something I've heard raised by traditional owners in Victoria, a process that they would like to go through of essentially reviewing laws on the books. So notwithstanding conservative opposition, it seems that the DRIP Act is not the end of the story in Canada. After it was passed, the Northwestern Territories have announced their intention, that's another province in Canada, have announced their intention to bring forward similar legislation. And in December 2020, the Trudeau government has introduced a bill to Parliament, Bill C-15, which is closely modelled on the DRIP Act and the earlier federal bill of C-262. So I think there's probably a high likelihood that this act will soon apply federally in Canada. Right, checking for time. I need to hurry up, but I'm now on to the last part, and so I will try and give this the justice it deserves, because we're now looking at how these things might be applied through the Victorian process. So firstly, we say that the UNDRIP stands as a ready-made international standard on Indigenous rights, and Australia has already endorsed it internationally. So on one view, it's only going to require the right political moment to move this document from aspirational to enforceable, and it would seem to us that the treaty process is that political moment. There's several models by which the UNDRIP can be systemically and structurally implemented, and we'll explore three. The first is and you will see obviously here parallels to the international examples we've just gone through. So the first one is embedding UNDRIP principles in treaty negotiation processes and protocols. The second is adopting legislation along the lines of the Canadian model. So that is law that affirms the application of the UNDRIP to the laws of Victoria and rectifying inconsistency with existing laws. And the third, which is not drawn so much from international examples, but is a creation of our own, is to include the UNDRIP rights as enforceable and justiciable in treaties. And we'll get onto what that means in a moment. So in terms of embedding UN principles into treaty negotiations and structures, I think this is quite straightforward. The UNDRIP could form part of a negotiation protocol embedded in the framework, and to apply in any treaty negotiations between the state and any traditional owner group. So much like with the British Treaty, the BC Treaty Commission, it would form part of a negotiation protocol, and likewise could form part of the Treaty Authority's foundational documents. So exactly mirroring what's happened in BC, but the Treaty Authority has as its function, as one of its central functions, to attend to the implementation of UNDRIP. Legislating the Canadian model. So as I said, the Canadian legislation both affirms the application of the UNDRIP to domestic law and requires this process of rectifying inconsistencies. We think this is a ready-made model for Victoria. And in some ways, Victoria already has legislation in place which has a similar character, which is the Human Rights Charter. The Human Rights Charter essentially requires all public authorities, state and local government departments and agencies to act consistently with the 20 rights that are listed in the Charter. Those 20 rights are taken from the ICCPR and include rights to freedom of expression, privacy, liberty, equality before the law, etc. It's also just worth noting that Section 19 has a part on cultural rights. It's the only part in the Charter that specifically refers to the rights of Aboriginal people and deals with their rights to preserve and protect their culture and practice their culture. So the Human Rights Charter requires public authorities to comply with these rights when they're developing policies or making laws or making decisions. But it's only the decisions and actions of public authorities that can be challenged. So what this means is it offers protection from the misuse of government power. So when the government does something, it has to act in accordance with these rights. But it can't actively promote human rights. That is, if the government is doing nothing, you can't use the Charter to force them into an action. This has led the Human Rights Charter to be described as a shield and not a sword. So that is, it's a defensive tool, but not an offensive weapon. The Human Rights Charter also imposes obligations on Parliament when enacting new laws. This requires that laws are assessed against the rights in the legislation in what's called a statement of compatibility. And if a law limits rights, the statement of compatibility must explain how and why. Parliament can still pass the law, but they're only meant to do so in exceptional circumstances. So as such, the Human Rights Charter is forward-looking. It is only concerned with proposed laws and doesn't look at laws already on the books. As we've discussed, that's different from the Canadian model, which would have a process of reviewing inconsistencies. And we say it's open for the Assembly to advocate for the introduction of legislation based on what they're doing in Canada, and it should be able to look both backwards and forwards. So it could adopt an action plan to seek out inconsistencies in existing legislation, and it could also affirm the application of the UNDRIP to the laws of Victoria, and this could operate somewhat like the Human Rights Charter, so that public authorities would need to comply with the terms of the UNDRIP when developing policy, services, making decisions and so on, and Parliament would have to ensure that all new laws are assessed against the terms of the UNDRIP in a statement of compatibility. That's the first two suggestions, and running up against the clock, I now move on to discuss our third proposal, which is making rights enforceable and justiciable in treaties. So we've talked about how the Human Rights Charter is described as a shield and not a sword. This proposal would make the UNDRIP a sword and be able to be used more proactively to enforce the rights of Aboriginal people. Essentially what this means is that whenever these rights were infringed, whether by government action or inaction, they could be challenged through the courts, resulting in enforceable orders against the state. And they could be realised through the direct and express recognition within a treaty. So what are justiciable rights? What do we mean by that term? Essentially, we're just talking about rights that you are able to have enforced by a court, that you're able to go to a court and get a court order that something occur. In human rights law, not all rights are considered justiciable. Usually civil and political rights, like the right to life, individual liberty, freedom of expression, etc., are considered justiciable, whereas rights around work, social security, health, housing, and so on are considered not to be justiciable. This is because they place different obligations on nation states. So to take an example, freedom of religion imposes a negative duty on the state not to interfere with people's right to religion. A right to education, on the other hand, may require the establishment of schools, the training of teachers, and you know, the state to go to a great expense. In Western legal systems such as Australia, it's not the role of courts to make these sorts of policy decisions. Instead, it's meant to be left to democratically elected governments. Accordingly, governments are usually reluctant to endorse rights as justiciable, where they may be forced through a court order to adopt some policy that they don't really agree with. Many of the UNDRIP rights, I think it's clear, if adopted as justiciable, would expose the government to this possibility. An obvious example is self-determination. An open right to self-determination might require a government of the day to do all sorts of things that it doesn't really support, to fund bodies and tribunals and so on. So although the governments are generally reluctant around these sorts of justiciable rights, there are international examples where it hasn't discouraged lawmakers. The South African Constitution is an example. Introduced in '96, it aimed to overcome the legacy of apartheid, and for that reason allowed a greater role for justiciable socio-economic rights. And that constitution does protect rights as justiciable to things like health, housing, healthcare, food, water, and social security. So there are examples where states have overcome their reluctance for these sorts of rights. So what rights should be entrenched from the UNDRIP as justiciable? It's not clear to us that all rights would be appropriately adopted in that way, but a treaty could include provisions stating that TO groups have a positive and justiciable right to things like self-determination, self-government, practice and revitalising cultural traditions, free, prior and informed consent, and so on. If these rights are adopted as justiciable, the state's obligated to ensure their implementation, and if they don't do that adequately, they could be taken to court and forced to do so. Of course, this leads to the further question: what does it mean in practical and real terms for the state to adequately act to meet these obligations? So you can recognise a right to self-determination or self-government, but that doesn't resolve how you actually get there. And it's likely that the state and traditional owners will agree about how you get there and exactly what is the extent of the state's obligation. If you leave those questions unanswered, for instance, that you have a right to self-determination and it's not answered by anything else, the courts will likely step in and answer that for you. Now that presents both risks and opportunities, because the courts may interpret and develop rights in a positive way, but the opposite is also true. They may develop rights, they may read down rights, and they may develop them in ways against Indigenous understandings. So we think some of these risks can be overcome by recognising the rights in the wider context of the treaty model. As you know, our treaty model sort of envisages the establishment of a sovereign body, the handing over of Aboriginal affairs, a framework for local treaties, and embedding these things within a treaty, which we would then say would stand as minimum obligations to reach these rights. And that framework and model is the real and practical way that you get to self-determination, that you get to distinct political representation and so on. So for instance, the minimum obligation for the implementation of self-determination could be the establishment of the TRB as a legislative body with sufficient funding for the TRB to deliver on its portfolio areas. While there's a risk that the courts can interpret a right to self-determination in unpredictable ways, this would be a flaw, but not a ceiling, essentially. So the court wouldn't be able to read down the right beyond those minimal obligations. This approach may also provide greater certainty around the enforceability of treaty. This is because if the treaty is breached, that breach would be actionable, perhaps as something like a breach of contract, but there would also be an underlying human right that the state was obligated to meet, and it would provide another standard by which the state's conduct could be judged. The upside too is that while there is a minimum standard, there is no maximum standard. So if these rights of self-determination and so on continue to develop beneficially in the international sphere, the traditional owners should be able to take the benefit of that development. So conclusion, and running very close to time, just to note that around the world, several jurisdictions are now moving to embed UNDRIP, and given the commitment to treaty in Victoria, it would seem that Victoria is likely to join them. We've focused on three methods: embedding UNDRIP principles in treaty structures, so in the negotiation protocol and the foundational documents of the treaty authority, legislating the Canadian model, and this third idea of having rights as enforceable and justiciable within treaties with a set of minimum obligations. We would suggest that the first two, A and B, are not ambitious. They should be, in our view, quite simple, and we would expect the state to sort of, that would be the minimum the state could do, really. The third proposal has not been tried anywhere else in the world, and therefore it might be more difficult to achieve. Why it's untried elsewhere, we say, is because nowhere has a treaty process been developed after the declaration was created. And as it is now the preeminent representation of international standards for Indigenous rights, it's natural that it should be considered for adoption in this way. But we should acknowledge that it's a complex legal task, and it's beyond the scope of this presentation to go into that complexity and problems that might arise with respect to compliance with the Constitution and so on. But we acknowledge those are there, and they would need to be explored if this was to be seriously pursued. Finally, just to note that we don't see these proposals as being introduced individually. We see them being introduced collectively. So that is because each essentially addresses a different subject area. The first, by embedding in negotiation protocols, you embed it in all policy and procedure. By legislating the Canadian model, you look at all current and future legislation. And by embedding the rights as justiciable, you also allow for their positive and practical implementation. And together, introduced in that way, it's a complementary system for the enactment of UNDRIP. And in our view, it provides a solid basis to underpin the treaty and provide a logical, moral and legally coherent footing for all future dealings between the state and the various traditional owner sovereigns of Victoria. And that's the conclusion, right on the buzzer, of that presentation. I'll now stop sharing the presentation and open the floor up to questions. So a question from Nina. Hi, Nina. Good to hear from you. It seems like Australia as a whole country would need to opt in to ratifying the UNDRIP, and how would the state of Victoria move ahead without national support? I don't necessarily agree with that. I think, as you see in Canada, that it's certainly been advanced at the provincial level. I don't think you need, if you want to adopt international law, traditionally it's done, I suppose, at the federal level, but there's no reason why it couldn't be done at the state level, as far as I can see. Oh, more questions. And my inability to use Zoom is not helping. Thanks very much for providing an informative presentation. Look forward to seeing where this goes. Could be very exciting times ahead. Thank you. Has the consideration of UNDRIP rights when drafting modern legislation resulted in any justiciable rights in Victoria or Australia, or are we stuck with the shield phase without the sword? Thanks for that, Declan. Yes, we are stuck with the shield phase without the sword. That's the current state of play. We have human rights legislation in Victoria and similar legislation in Queensland, and those have been introduced with some controversy. It's what the political will can achieve in Australia kind of seems for the moment limited to that shield position. Any chance of having a copy of your paper placed on Facebook? Georgina, I'm sure we can do that. It's also available on our website. If you just go to fvtoc.com.au, it'll be there, but we'll try and get it on Facebook. Can a future federal government cancel a state government legal setup? No. I mean, I think part of the complexities that will come into play here will be the interplay between the state and the Commonwealth, and you know, there might be potential for challenge that would have to go through the High Court. And this is what I was kind of pointing to when I said there are sort of constitutional complexities about introducing something like justiciable rights. You know, as ambitious as we may want to be, we also have to think, we also have to make sure that this process will withstand a High Court challenge. And that will have to play into people's minds, and they'll have no doubt get extensive legal advice on all those aspects to make sure that that it does. That notwithstanding that, I think there is a lot of scope for creativity and ways we can achieve great things. G'day, Sam. Has any legislation been amended to accord with the DRIP Act in BC? Good question, Sam. I haven't been able to find any. I went back yesterday, this paper was written sort of at the start of 2020, I think, and which was just after the DRIP Act was introduced. And I went back yesterday and tried to find some examples, but there doesn't seem to have been a whole lot done in the last 12 months. And I suspect we all know the reason why. I think COVID has slowed everything down around the world. But so no, to my knowledge, nothing is yet to be amended. Declan's put a link in there to the papers. Thanks, Shalee. A lot of Kellys on the line. What would be the difference between the implementation of the Canadian model and the enforceable justiciable rights through treaty? Would the Canadian model be broader? No, I don't think. I think the Canadian model would be narrower, and that's why we are saying it's not one or the other, but both. So we would want something like the Canadian model, but then we would want to go further and have justiciable rights through treaty. And this gets a bit confusing because the Canadian model essentially seems to set up a process whereby they can review existing legislation and perhaps future legislation. It has this strange phrase in it that it affirms the application of the UNDRIP to BC law. I don't think that's interpreted as, that's unlikely to be interpreted as the UNDRIP is now just the law of BC. It's more likely that someone could challenge a piece of legislation saying it's not compatible and what have you, but couldn't bring a legal action saying you now have to deliver self-determination, for example. And essentially what we want through the justiciable rights is the ability to take legal action to force a state government or any government to implement those rights. I hope that's clear. Oh, geez, big questions. Regarding the iconic RDA, what can stop the Commonwealth in future from suspending the RDA, as it did in the NT intervention, which continues to deny basic human rights? And how would the suspension of the RDA, oh, I've lost the question. I've lost that question. I'll try and recall what that question asked me. So basically said, what's to stop the Commonwealth from suspending the RDA and how would that affect this process? Well, essentially nothing stops the Commonwealth from suspending the RTA. They proved that with the intervention. I don't think its suspension would have a great impact on this process because it is led by the state government. so there wouldn't be any direct implication. I don't think that the suspension in the territory had greater effect because it is a territory, and the Commonwealth was able to directly intervene and essentially mandatorily acquire land and do other things that it wouldn't be able to do, I think, in Victoria. I hope that answers the question. I did lose it, so I'm not sure I got the whole thing, but it is an interesting question. What does traditional lands mean in the NRA? Is it only Crown land returned to TO groups as part of the TOSAC settlement? How might this be expanded if UNDRIP was embedded in a deeper way? So the NRA and all settlement acts cover all Crown land, essentially, and all public land. So that's what it refers to. I might have used the phrase traditional lands, but under the NRA, in fact, you only get rights over existing Crown land. How might this expand if UNDRIP was embedded in a deeper way? Well, that's a difficult question to answer. I think there is scope within treaty negotiations to look at more than Crown land, to particularly look at freehold land that is otherwise owned by state agencies. I think all of those things are on the table. I don't necessarily know they're on the table because of UNDRIP, though. I think they're on the table just because it's just. I'm not sure I've done a great job answering that question. What would be the difference between the implementation of the Canadian model? Oh, sorry, I've answered that one. Thanks for all these great questions in which I'm getting lost. So just back to that Racial Discrimination Act question, the final bit of the question was, if the Commonwealth suspend the RDA, how would the suspension of the RDA impact UNDRIP if ratified in Victoria? It wouldn't, essentially. The RDA would only relate to Commonwealth activities, and the Victorian government is free to take its own path on those kinds of things. Right, I think that I've answered all the questions. If there aren't any more, we might be able to wind up. Thank you for staying with me a little bit over time. Yeah, if anyone does have any more questions or would like to discuss anything else, just feel free to drop me an email or give me a call, and welcome to have a chat. As I said, you can find all of these papers on our webpage, and the presentations are also posted on our Facebook page. With that, I might just see if Paul's still there and we can say goodbye.
Oops. I turned the camera on and off again. Thanks, Dan. Yeah, thank you very much for a very comprehensive and accessible presentation. I think it certainly enhanced my understanding of UNDRIP and its application, and looking at the foundations, what can we learn from the other jurisdictions, and how can we apply that learning into Victoria as the treaty process moves forward. So yeah, a great presentation, lots of good, interesting questions, and looking forward to the next one. So everyone who's still on the line, yeah, look out for the next presentation. It'll be posted on our Facebook page, and hopefully you can come along and continue to participate in these presentations and bring some more questions to those as well. So thanks, Dan. Thanks, everyone. And Kanitba, thank you. Hope you have a great day.
Thanks, Paul. Thanks all.